Tell us about your professional background, your experience in bankruptcy.
Sure, Roland. Thanks for inviting me. It's interesting that I come to this mainly as a corporate transactional lawyer, but I also was in that role in 2008 when things came crashing down and Lehman happened, and they were basically looking for warm bodies at the firm I was working at as a relatively junior associate, and so I got pulled into the bankruptcy world at that point. I learned the ropes, and I maintained a presence within the bankruptcy and restructuring world, working on distress transactions, both from a transactional perspective and occasionally getting involved in a larger Chapter 11 case now and again. So I have, seen my way around the bankruptcy court, and do have that experience. And in part, I found myself in the same position in 2021. And I actually am new to Errant Fox. I joined at the beginning of 2021, before the pandemic started. And one of the things that interested me in Errant Fox, I had been foreseeing, and you talk to the economic forecasters, and the downturn was coming. And the thinking at my point in January 2021 was that the downturn is coming, and it would be great to be part of a larger bankruptcy restructuring team like the one at Errant Fox. So I was really excited about that opportunity, and it ultimately turned into a very different type of economic downturn that nobody was expecting come March 2021. So I've always had my hand in things, and as the pandemic has progressed, I found myself in a spot without a whole lot of transactions going on. I made sure to wrap everything up right before I left my old firm. And so I also got thrust into the role of being sort of one of the experts at Errant Fox on the PPP program, a brand new field, obviously, that a lot of people were rushing to learn about, and everybody was sort of starting from scratch on. So I jumped into that role. And with my prior background in restructuring, I always kept sort of a keen eye on how this affected people in bankruptcy. And that was one of the first things that came out. There was an early case in Southern District of Texas that a debtor basically challenging their ineligibility for PPP. So myself and some colleagues were tracking that development as it happened, and it was interesting to see how it unfurled in connection with all the other changes in PPP.
Yeah, and Lehman Brothers is still with us, as you know. I just got retained to defend a clawback filed by Lehman Brothers.
Yeah, luckily I had most of my, I had a couple of claims pending. A lot of claims sales going on. So I got out of them several years ago, but I still get the daily emails.
So what are the highlights? So how would you summarize with respect to bankruptcy, the CAA, and I guess talk about that a little bit?
Sure. So it was interesting in December, the PPP program was effectively coming to an end, and Congress took up the issue of what do we do with it now. There's still people hurting, people who have gotten the loans who haven't been able to effectively use them. How do we need to change the program to allow it to continue to benefit borrowers and the struggling U.S. economy? So at that point, again, me and my team, we were deeply involved in following everything that was going on. Even the Errant Fox government relations lobbying team was involved in some of the drafting of elements of the new statute. So we were deeply involved following things. And honestly, I didn't see the change to the bankruptcy issue coming. The case in Texas that I had mentioned had been brought up on appeal. The debtor in that question had been denied the right to participate in the PPP program, and it continued through appeal. I believe the cases were ultimately decided in the Fifth Circuit. That specific case went up to the Fifth Circuit. Another decision came down in the 11th Circuit, both denying in those circuits the opportunity for debtors to participate, and those circuit courts standing with the SBA, which had basically said that debtors are too much of a credit risk for the SBA to take on with the defense being it's a grant program. You have so much credit risk with everybody else you're lending to. These debtors don't create any more of a risk. That said, I was somewhat surprised to see within the draft statute that there were proposals to address a handful of issues that arise in bankruptcy as a result of the PPP. One of them being the eligibility of debtors to be borrowers under the PPP program. Another one to address how, really, I think it came from the real estate world and landlords being encouraged by their banks and by the others in the commercial real estate community to work with tenants to get them past this and not to, be hounding them to pay their back rent. And the issue came up of, well, what about the fact when this business ultimately enters Chapter 11, I'm going to have this resounding preference claim because of the way that I was being nice to my tenants and allowing them to defer payment.
So you think landlords were lobbying for this, and that's how it came to be, or no?
I'm not positive. I wouldn't be surprised if the commercial real estate market was involved in getting this out there. And then, a natural spinoff of what about other vendors that are doing the same thing with their routine customers. So I wouldn't be surprised if those industries somehow said, if you allow the tenants to continue going on and continue, getting these forbearance agreements to delay payment because they have no income. Restaurants are a great example. Just keep them there. We don't want to shut down the restaurant. We know they're not operating. But if you're generous with them, we're pushing the banks to be generous with you on your mortgages. And ultimately, this issue just came up. I'm sure in a handful of places, and they said, well, we have to do something to prevent this issue to get the broader policy move forward. That's my guess. I don't have any concrete evidence on that.
Okay. And so what is the new defense that preference defendants now have? What's the safe harbor? If you could summarize it.
Sure. So the safe harbor basically provides for, I'll keep it in the landlord-tenant context, but it could apply to other vendors. So where landlords and tenants were under an existing lease, they have the option to negotiate to essentially forbear on payments and to push them out. And those payments, if they end up being made within the 90-day preference period, immediately prior to a filing, those payments, which came due earlier and out of the generosity of the landlord's heart, they agreed to forbear on the collections, those will not be considered preferential payments. So there's a handful of rules that are built in to structure the program and prevent everything from falling into this category. But the specifics on it are that there has to be an agreement or an arrangement, is the language of the statute, between the landlord and the tenant as to which payments will be deferred. And that agreement had to have been entered into after March 13th, 2020, after the date the disaster was declared. So therefore, it's in contemplation of COVID. They didn't say specifically because of COVID, but that's clearly the intention by saying that it had to have taken place after March 13th.
It basically rewards vendors and landlords for entering into restructuring agreements.
Right.
Or not necessarily rewards them, but protects them from the implications of entering into restructuring agreements.
Right. Had they done this without this additional protection, then they agreed to restructure. They push the payment down the line for another 6 months, and in month 5 they get, or a month 6 they get paid, and in month 7 Chapter 11 is filed, and there's this huge 6-month payment that comes in as opposed to just the routine 1 month in that 90-day period.
It kind of disadvantages people that don't know about this. I mean, if you're a vendor, it really encourages you as a vendor to enter into a restructuring agreement. But since a lot of them are not going to know about this act, they're not going to enter into restructuring agreements. And it sounds like if they did, they'd be automatically protected from preferences. Like everybody would enter into restructuring agreements, and so it's gonna protect those that are pretty savvy.
Right. I think that's right. And this hasn't been widely publicized. I mean, I'm sure that the larger suppliers are looking at it and saying, they've got a legal team and they found it, and somebody is tracking this and figuring out how to implement it. And exactly that, they're taking it across their whole, I mean, obviously there's a lot of business considerations that go into, giving these, making these arrangements. But at the same time, there's some protection and they would take advantage of it. I mean, the business side of it is the longer you push out the payment, the less operating funds you have and the less likelihood you'll ultimately get paid. So
plus you don't know if your debtor is going to be filing bankruptcy. So exactly. It's, if you really suspect that you're in the preference period, then actually, does the restructuring agreement have to be entered into prior to the preference period?
It doesn't. It has to be entered into after the start of COVID, but you could theoretically enter into the agreement, but it only applies to the payments made after the agreement date. So you can enter into the agreement on September 1st, get a payment on September 15th, and if they file on September 30th, then only that one payment would be covered. But if it was a deferred payment, they owed 6 months of back rent at the time they paid you on September 15th, then it's not that September 15th payment can't be pursued as a preference because it's on account of payments that were previously due.
So as a practical tip for landlords and vendors, if you think your customer is going to be filing bankruptcy within the next 3 months and they've been paying out of the ordinary course or late, then you want to enter into a restructuring agreement with them right away to protect any payments you get after the restructuring agreement.
Exactly. The sooner the better to enter into the restructuring agreement. And the other element of this, which is intended to protect the tenants and to keep the landlords in check while the landlords are getting a benefit from this, they're kept in check by not adding on extra fees and interest. So the rules specify that you're only protected to the extent that these are fees that would have otherwise been due in the normal course. So if as part of your restructuring arrangement, you say, well, I'm going to push these down the line, but you're going to owe me an additional $200 a month for every month that passes. All of those add-ons are not free from a preference claim. If it was already in your existing lease that you're going to have a late charge and you're going to have 1% interest, that, as long as it was in place before March 13th, that is still applicable and you can still charge your interest as you would have. You just can't add on to that and say, in order for me to be a nice guy, you've got to pay me to be a nice guy. Those payments would be considered preferential payments, the amount that a tenant is paying in order to get the benefit of a deferral agreement. Right.
And the landlords that push for this are aware of that. And so they're going to be kept in check.
Right. Right.
Whereas vendors don't know anything about it. Like small trade creditors they're not really going to be kept in check because they're probably not going to know about this law. And so they're just going to do what they're going to do. But restructuring agreements will be protected. And they're probably in 2020, there probably were a lot more restructuring agreements than before. So that's a benefit for trade creditors.
Right. And as you move this to the trade creditors, you're right. On the small trade creditors, they're not going to pay attention to this. They're probably not going to pick up on it. Maybe once they get a preference claim in some respect, they'll notice it and start acting differently. But the other interesting piece in the way that it applies to trade creditors as opposed to the landlord-tenant relationship is that there does have to be an executory contract in place. So that's sort of the way that they limit the applicability. I mean, it's a very broad term that they use of suppliers who this can apply to, but it has to be in connection with an executory contract. So I think the audience here knows enough to parse whether or not the underlying contract at issue, A, was in place prior to March 13th, the restructuring arrangement was reached after March 13th, and there's an underlying executory contract.
Does the contract have to be executory at the time of the payment?
That's my understanding.
Okay, well, if you don't know what that means, I think that's another video.
Yeah, I mean,
All right.
I know, I see the question there, and I have not thought about it specifically. So that's a good question, but I haven't really thought about it.
Which one?
Whether it has to be executory at the time of the payment.
I guess that'll be litigated.
Yes, and so separately, and you can include this or not, I did do some fast research yesterday. I've seen 0 decisions on this piece of the new preference. 547J is the amended subsection that provides for this exclusion. So I haven't seen any orders entered. I shouldn't say orders, at least any decisions entered on this specific subsection.
I guess it's because no one knows about it. But now that because of your articles and maybe this interview, people are going to wake up to this defense. So the debtor only has to thank you for bringing in less preference money.
Exactly. That'll be, and I'm curious to see how the trustees will react to this also, because I wouldn't be surprised if there's a handful of trustees, and I think they'll continue to use their standard mechanism of, here's the list. I'm going to send a demand letter to everybody on the list. I'm not going to, even the obvious defenses, nobody can really fault them. That's the practice. And, people aren't going to necessarily be shying away from making the claim just on the basis of the defense existing. The language is a little bit different, and maybe there's a reason that trustees and estates should be looking at this more carefully, because it's basically saying that the claim doesn't exist, as opposed to it's a defense to the claim. So,
well, that's interesting. Well, yeah. That's interesting. Is there a due diligence requirement as part of this? I mean, I guess if the claim doesn't exist because of this fact scenario and they file a complaint, is that a frivolous?
Yeah, complaint? That's what I was. Honestly, I'm just thinking about it now for the first time. I'm just trying to look back the language. Trustee may not avoid a transfer under this section for a covered payment of rental arrearages or a covered payment of supplier arrearages. So if it's impossible to avoid the transfer and you make a claim knowing that those exist, I mean, certainly there's, I think, ample room for a trustee to argue that it's not a covered payment of rental arrearages, or there was no way for them to know. So I do see this translating back into a defense mechanism, but it is worded differently as a directive towards the trustee. You may not avoid, as opposed to here's a defense to avoidance. So yeah, as I was saying previously, the eligibility question for debtors was somewhat addressed in the new Consolidated Appropriations Act, but it's a very unique and something that I haven't really seen in a statute, where the statute Congress has taken the initiative to direct the SBA to make PPP loans eligible for specific subsets of debtors, namely Subchapter 5 and Chapter 12 and Chapter 13 debtors who operate independent businesses. But the unique aspect of it is once the SBA conveys to the U.S. Trustee's Office that it has set up the framework for those PPP loans. So the SBA certainly hasn't done that yet. I've heard no rumors that they intend to do it. While Congress provided that these classes of debtors are technically eligible, it's still incumbent on the SBA to promote that eligibility, and to adopt it into its regulations, especially the wording where it says basically that you will do this, but only after you do this other thing. So as of now, debtors are still ineligible. All classes of debtors cannot actually seek a PPP loan. And I'll note for the audience here that there is a case pending out of the District of Maine that's gone up to the Second Circuit, arguing a discrimination argument under 525A, basically saying that the federal statute is preventing this what's effectively grant money being distributed to debtors. So it's an interesting argument. The SBA has certainly dug in and made arguments to the contrary that, as I alluded to earlier, it's a loan program and we have to manage our risks, and debtors are unreasonable risks. That's their main argument. But we'll see how it plays out. And like I said, the Fifth and 11th Circuits have come out strongly against allowing the debtors to take PPP loans.
But Tal, don't they get a super priority lien?
They do. And so not only did they say that they're eligible, they created a system in order for how you still have to bring it to the court. You have to get approval to take the loan. So that's a good point you raise, that the Congress was really intending for this to happen at some point. And now we're getting, there was a bill passed just on March 25th, allowing the extension of the deadline till May 31st. But as we get nearer and nearer to that deadline, and the SBA doesn't act on allowing debtors, it's sort of throwing it back in the face of Congress to say you created this whole framework for what has to happen in the bankruptcy court and how that gets prioritized, when it's all just sort of a fallacy at this point, because nobody can actually access the loans.
Unless one of these courts rules that it is discriminatory under the
Correct.
bankruptcy code, and that might resolve it.
Right. And the closest court that it would happen at this stage is the Second Circuit. There was a case pending in the Seventh Circuit, but it was withdrawn. So right now we're in briefing in the Second Circuit case out of the District of Vermont.